In 1957, Harlem, a prosecutor slapped Bumpy Johnson in open court in front of a judge, a jury, and men who understood what public humiliation could cost. 5 days later, that prosecutor's career was over, the case was dead, and the most dangerous defendant in the room walked free. When violence fails in public, who actually holds the power? Manhattan Criminal Court Courtroom, 6 November 1957. The room carried the quiet certainty of an ending already agreed upon. Wooden benches were filled, early coats folded neatly, eyes forward, as if everyone understood they were here to witness confirmation, not debate. The prosecution believed this case was finished before the first question was asked. 2 years of investigation had produced binders thick with paper names underlined in red pencil, and a narrative rehearsed so often it no longer sounded like an accusation, but a conclusion. This was supposed to be the day the state proved it had finally cornered Harlem's most untouchable figure. Robert Hansen stood at the center of that confidence. At 38, he had never lost a major case. His record was clean, his reputation sharper, and his ambition impossible to miss. He moved with the ease of someone used to winning rooms before juries ever spoke. To colleagues, this trial was not a risk, it was a milestone. Across the aisle, the defense table was quieter. No visible urgency. No whispered strategy. Just papers-aligned chairs pulled in, and a man who did not look like someone waiting for a verdict. Bumpy Johnson sat straight-backed, hands resting calmly, eyes steady, as if this courtroom belonged to him as much as it did to the judge. When his name was called and he stepped into the witness stand, the shift was immediate. The air tightened. Some in the gallery leaned forward, others avoided looking at him altogether. Harlem had taught people what it meant when powerful men were humiliated in public and what usually followed. Bumpy Johnson did not bring any of that history with him to the stand. No glare, no challenge, no attempt to dominate the room. He took the oath, adjusted his jacket, and waited. The silence stretched long enough to become uncomfortable. Hansen began confidently. The early questions were procedural control designed to establish rhythm and authority. This was where defendants usually slipped too eager, too defensive, too angry. Bumpy gave nothing. His answers were brief, measured, and precise. Yes, sir. No, sir. I don't recall. Each response closed a door instead of opening one. Minutes passed, then more. The jury watched closely. This was not the performance they had been prepared for. They had expected agitation, maybe arrogance, maybe a crack. What they were seeing instead was discipline. The judge noticed it too. He had presided over hundreds of trials and recognized patterns the way other men recognized weather. Defendants under pressure leaned forward. Their voices rose. Their hands betrayed them. Bumpy Johnson did none of that. He remained still, almost clinical, as if the questions belonged to someone else. Hansen adjusted. His tone sharpened. He tried proximity, stepping closer to the stand. He tried repetition, circling the same points from different angles. Each time the answer landed softly and went no further. The courtroom began to sense something shifting, though few could yet name it. Behind the jury box, a man from the press quietly set his pen down. There was nothing dramatic happening, no shouting, no objections, but the tension was unmistakable. This was the sound of a case failing without noise. The prosecution had built its confidence on one assumption, that Bumpy Johnson could be pressured. That assumption was unraveling in real time. With every unanswered trap, the certainty in the room weakened. Faces that had entered expecting closure now carried doubt. Bumpy did not look at the jury. He did not look at Hansen for long. Most of the time, his eyes rested on the judge, as if acknowledging the only authority that mattered. It was not submission. It was recognition. By the time the first hour passed, the courtroom had stopped waiting for a mistake. It was waiting for something else, an interruption, a shift, a force strong enough to break the stalemate. Hansen felt it. The room felt it. The silence grew heavier. This was no longer a witness examination. It was a test of control. And as the clock crept forward, one truth became harder to ignore: the verdict everyone had arrived expecting was no longer guaranteed. Something else was forming beneath the surface, something unplanned, unstable, and dangerous. According to the official court record, the defendant displayed no disruptive behavior and remained cooperative throughout this portion of the examination. The trap had been set carefully. But the man inside it had not moved at all. The prosecution called it airtight long before a jury was sworn. 2 years of investigation had produced a mountain of paper ledgers, copied and recopied bank slips flagged with pencil marks, charts drawn to make money look like motive. On paper, the story was clean. Too clean. It showed a city that finally had its evidence and a man whose reputation had finally caught up with him. There were names, many of them, street collectors, bookkeepers, men who claimed they knew how the numbers ran where the cash moved, who gave the orders. Each statement fit neatly into the next. Dates aligned, amounts matched. The binders stacked behind the prosecution table looked heavy enough to bend wood. The press noticed immediately. Before the trial even began, headlines had already chosen their language. This was the case prosecutors had been waiting for. The one that would prove organized crime in Harlem could be dismantled with documents instead of raids. Editorials spoke of inevitability. Radio reports hinted that the only mystery left was sentencing. Inside the courthouse, that confidence hardened into expectation. Jurors were shown summaries designed to guide them forward without friction. Charts simplified complicated flows of money into arrows and totals. The message was subtle but unmistakable. This was not a question of guilt, only a demonstration of it. The witnesses came one by one. The first spoke with certainty. He described collections routes, habits. His voice was steady, rehearsed. On cross-examination, the defense asked about dates. Small questions, innocent ones. The answers shifted slightly. A Tuesday became a Wednesday. A winter month slid into spring. The jury took note. The second witness went further. He claimed first-hand knowledge, proximity authority. The defense asked about prior statements, about conversations with investigators, about promises. The word compensation surfaced carefully, then lingered. He adjusted his tie. His certainty softened. The room stayed quiet. By the third witness, the pattern had emerged. The prosecution still had numbers, but the numbers now depended on people. And people under questioning carry weight paper never does. Each cross-examination took longer than expected. Not because of theatrics, but because the defense moved slowly, deliberately, letting silence do the work. Jurors leaned back. Pens paused mid-note. The prosecution objected less. They watched, calculating whether intervention would only draw attention to fractures already visible. Outside the courtroom, reporters began changing their language. Strong case became ambitious. Historic softened into complex. Small shifts, but meaningful ones. The financial records were next. They had once been the spine of the case. Spreadsheets projected onto boards, transactions highlighted, totals circled. The defense did not deny the existence of money. They questioned ownership, control, attribution, who touched what and when. The prosecution answered with assumptions that had sounded reasonable in offices, but less so under oath. Nothing collapsed dramatically. No witness stormed out. No document was thrown aside. The case did something worse, it thinned. Certainty drained slowly like air from a tire until movement itself became unstable. By the time the prosecution rested, the binders behind their table looked unchanged. Still heavy. Still impressive. But the weight had shifted. They now pressed inward, demanding belief rather than earning it. The jury felt the difference. They were no longer being led. They were being asked. The judge watched carefully. He had seen cases lost with less damage. He had also seen strong cases recover. This one, however, was running out of margin. The prosecution still had one card, left one decision that could either steady the narrative or expose its weakness completely. Calling the defendant. Most defendants never testify. It is the oldest rule of survival in a courtroom. But this case had already broken expectations. The paper had failed to seal it. The witnesses had introduced doubt. The prosecution needed something human, something reactive, emotional, unpredictable. They believed the stand would provide it. What they did not account for was the difference between a man built by rumor and a man trained by pressure. They had prepared for defiance, anger, maybe arrogance. They had not prepared for discipline. As the courtroom waited for the next phase to begin, the prosecution still believed they were ahead. The record still favored them. The structure still stood. But paper once questioned does not recover easily. Several witness statements presented during this phase were later scrutinized by journalists for the circumstances under which they were obtained, despite having been admitted without objection at trial. The case looked perfect on paper. It just wasn't holding up in the room. Most defendants never take the stand. It is the first rule whispered in holding cells and repeated in law offices: don't give the prosecution your voice. Silence protects. Silence limits damage. Silence keeps control where it belongs on paper and procedure, not emotion. That rule was broken deliberately. When Bumpy Johnson rose from the defense table and walked toward the witness stand, the movement alone unsettled the room. Chairs shifted. A murmur rippled through the gallery before being swallowed by the judge's glare. This was not supposed to happen. Men accused of running empires did not volunteer themselves to cross-examination. They hid behind counsel. They waited. Bumpy didn't wait. He adjusted his jacket once, placed his hand on the rail, and took the oath without ceremony. No pause, no hesitation. He did not look toward the jury for approval or toward the prosecution with challenge. He looked straight ahead as if the decision had been made long before this morning. For the prosecution, the moment felt like an opening. For 2 years, they had built a case that relied on inference and intermediaries. Now they had the source himself. This was where people slipped. This was where reputations cracked. The strategy from the defense was almost invisible. There were no speeches, no dramatic gestures. Just instruction given quietly days earlier and followed with discipline: now answer only what is asked, say nothing extra, and close every door the moment it opens. Hansen began with confidence restored. This was his territory again. His questions came clean and direct, designed to provoke expansion. Did you run illegal gambling operations? No, sir. Did you control the numbers racket in Harlem? No, sir. Each answer landed softly and stopped. He tried again. Same result. The jury watched closely. They had been prepared for a performance denial laced with attitude evasion wrapped in charm. What they were seeing instead was restraint. Bumpy Johnson did not argue innocence. He did not sell himself. He simply refused to participate in the narrative being built around him. Minutes passed, then more. Hansen changed angles. He asked about associations, locations, arrests. Bumpy answered each one with the same calm economy. Arrested, not convicted. I live in Harlem. That's not illegal. The words carried no heat, no defiance, just precision. The judge leaned back slightly, hands folded. He had seen defendants talk themselves into corners with less prompting. This man was doing the opposite. Every sentence reduced surface area. Every pause denied momentum. By the end of the first hour, the prosecution's rhythm had flattened. Their questions were still sharp, but they no longer cut. Hansen stepped closer to the stand as if proximity might create pressure. It didn't. Bumpy did not move. The second hour began with more insistence. Hansen raised his voice slightly, not enough to draw an objection, just enough to suggest urgency. The jury felt it. So did the defense. They said nothing. This was no longer an interrogation. It was a waiting game. The prosecution needed to crack any sign of irritation, sarcasm, impatience. They needed the man on the stand to remind the room of who he was supposed to be. Instead, he remained composed, answering each question as if it were the only one that mattered. Behind the gallery, reporters stopped writing full sentences. They underlined phrases. No, sir. That's not illegal. Simple responses repeated without variation. There was no quote to sensationalize, no moment to dramatize. Hansen glanced at the clock. 2 hours had nearly passed. The jury had not been given anything new. The record was growing, but the story was shrinking. This was the risk of calling the defendant. The stand does not guarantee exposure. Sometimes it creates contrast. The more aggressively the prosecution pressed, the more disciplined the witness appeared. Control was changing hands without a word being spoken about it. By the time the judge announced a brief pause, the courtroom felt different. The certainty that had entered with the prosecution's binders was gone. In its place was something colder, the realization that the case now depended on whether pressure could replace proof. Bumpy Johnson stepped down briefly, his expression unchanged. He did not look relieved. He did not look tense. He looked exactly as he had before contained. The prosecution still believed they could force the moment. They believed the next questions would finally break the balance. They were running out of time. Court records later confirmed that the decision for the defendant to testify was a calculated strategic choice made by the defense, not a reaction to developments inside the courtroom. 2 hours had passed. There was still no crack. The questioning did not stop. It tightened. Robert Hansen pressed forward as if momentum could be manufactured by force alone. His voice stayed controlled, but the pace quickened. Question after question, each designed to corner, provoke, or exhaust. It was the kind of sustained pressure most witnesses failed under, not because they were guilty, but because they were human. Bumpy Johnson gave him nothing. 2 full hours passed without a single emotional shift. No raised voice, no visible irritation, no slip of language that could be pulled apart and reused. Each answer arrived measured, clean, and closed. The rhythm never changed. The witness did not speed up. He did not slow down. He did not glance at the jury for reassurance or at the judge for protection. That constancy began to matter. Jurors noticed first. They had entered the room expecting deterioration, the slow unraveling that comes when questions repeat and patience thins. Instead, what they saw was consistency. The longer the examination lasted, the less dramatic it became. And that absence of drama unsettled expectations more than any outburst could have. Hansen adjusted again. He leaned harder into implication, associations, proximity, reputation. He framed questions that suggested conclusions without stating them outright, hoping the weight of suggestion would do what direct accusation could not. Bumpy responded the same way, each time separating fact from inference without comment. The jury shifted. Pens stopped moving as often. A woman in the second row crossed her arms, then uncrossed them. A man near the aisle tilted his head slightly, listening more closely now. Doubt does not announce itself. It arrives quietly, one unanswered expectation at a time. From the bench, the judge watched the clock. He had allowed latitude, expecting the prosecution to find its footing. But this was no longer a standard examination. It had stretched past its planned limits. The prosecution was circling, not advancing. Hansen felt it. He could feel the room drifting away from the narrative he had carried in with such confidence. The binders on his table were still there. The case was still technically intact. But the moment the human moment juries rely on to connect evidence to belief was slipping. He raised his voice slightly again. Not enough to draw an objection, just enough to sharpen the edge. He stepped closer to the stand, reducing the distance between himself and the witness. It did not help. Bumpy did not lean back. He did not flinch. He did not react at all. 2 hours and the imbalance had reversed. What was supposed to be pressure now looked like persistence without payoff. The more Hansen pushed, the more controlled the witness appeared. Control had become visible. The courtroom grew quieter, not louder. The absence of conflict drew attention to itself. This was no longer about answers. It was about endurance. Hansen glanced again at the clock. He was behind schedule. The examination had been designed to escalate, to build toward a revealing moment. Instead, it had flattened. Time, which normally works against defendants, was now working against him. He knew what this meant. If the defendant left the stand intact, the prosecution would be forced to rely on the same paper that had already begun to fail. The jury would be asked to remember documents instead of moments. That was a dangerous position. The judge cleared his throat. A subtle sound, but in this room it carried weight. Hansen nodded once, barely perceptible. He understood the signal. He was expected to move on, but he wasn't ready. This was the moment prosecutors dread, not because the case is lost, but because the window to save it is closing. Hansen felt the pressure compress inward. The room, the jury, the clock, all of it, narrowing his options. He still believed there was a way to force reaction, to provoke something human, something undeniable. 2 hours had passed. There were still no cracks. Court records later noted that the duration of this examination exceeded the prosecution's original time allocation without producing any significant deviation in the witness's demeanor. There comes a moment in every failing case when a prosecutor must decide whether to step back or force the issue. For Robert Hansen, that moment arrived quietly disguised as routine. He shuffled his notes, paused longer than necessary, and looked up at the witness stand with the expression of a man calculating risk in seconds. The jury was watching now, not passively, actively. They had endured 2 hours of questions without a single rupture. The defendant had not stumbled. The room had not tilted. The case had not advanced. What remained was one question, one attempt to turn patience into proof. Hansen chose provocation. He framed it carefully, at first testing the edge. He spoke of reputation of whispers that followed the defendant wherever he went. He leaned into suggestion, letting implication do the heavy lifting. The question hovered between accusation and insult, crafted to pull emotion into the open. Bumpy Johnson did not respond immediately. Not out of hesitation, but because the question itself did not deserve more than it was. When he answered, it was with the same restraint he had shown all afternoon. No expansion, no correction, just a refusal to accept the premise. Hansen pressed again, sharper this time. The words grew heavier, the tone less measured. The courtroom felt the shift. This was no longer examination. It was confrontation. The defense rose before the sentence could finish. Objection. The judge's gavel followed instantly, cutting through the air with a sound that carried authority. The objection was sustained. The judge's voice was firm, unambiguous, and heard by every person in the room. The prosecutor was instructed to rephrase and to do so without editorializing. The warning was clear. Hansen nodded, but did not step back. He stood where he was closer now than before, as if proximity might substitute for leverage. His eyes did not leave the witness. He tried again. This time the line was crossed. The insult was brief, almost casual in delivery, but unmistakable in intent. It carried with it everything the prosecution had failed to prove, contempt disguised as certainty, frustration sharpened into language. The gallery went still. Even the stenographer hesitated, fingers hovering above the keys. The defense was already on its feet. Objection, inflammatory. The gavel struck harder. The judge's patience, stretched thin by the length of the examination, finally broke. The reprimand was no longer procedural. It was public. The prosecutor was ordered to stop, to rephrase immediately, and to apologize to the witness in front of the jury. This was the line Hansen could not retreat from. For the first time all afternoon, the balance of power in the room was undeniable. The jury had heard the warning. They had seen the judge intervene. They had watched the prosecution lose the room it once controlled. Hansen knew it too. If the defendant walked away from this stand unshaken, the case would not recover. The witnesses had weakened. The documents had lost authority. The only thing left was reaction, and reaction could not be requested politely. He took a step forward. The defense saw it. The judge saw it. The room sensed something breaking beneath the surface, something no rule of procedure could contain. The last question was no longer about facts. It was about forcing a moment that evidence had failed to produce. Bumpy Johnson remained still. He did not lean away. He did not raise his voice. He did not look toward the jury or the judge. He looked straight ahead, waiting. The stillness around him became heavier than any accusation. Hansen understood then fully and too late that time was no longer his ally. If control was not seized now, it would be lost entirely. The case would end not with proof, but with silence. The courtroom held its breath. There would be no more questions after this. No official audio recording exists of this exchange. The sequence of events has been reconstructed from multiple contemporaneous accounts that align on the critical moments. At 2:34 p.m., the room lost its balance. Robert Hansen moved first. It was not sudden, but it was unmistakable, a step that broke the boundary every lawyer understands without being told. The distance between counsel and witness collapsed in a way that felt wrong before it became dangerous. The judge registered it an instant too late. Hanson's hand came up. The sound was sharp, flat, and final. It cracked across the courtroom like a board striking wood, loud enough to reach the back row and precise enough to leave no confusion about what had happened. 50 people froze at once. The judge inhaled sharply. The stenographer's fingers stopped midair. The bailiff's posture shifted, instinct racing ahead of protocol. For a fraction of a second, the courtroom existed without rules. Bumpy Johnson did not move. The red mark appeared almost immediately on his cheek, the shape of a hand clear enough to be recognized by anyone who looked. His head had turned slightly with the force, but he did not stand, did not raise his arms, did not respond in kind. The reflex every man carries to protect a strike back was there. It had simply been denied permission. Silence filled the space where reaction should have been. Hanson seemed to realize what he had done only after the sound finished echoing. His face drained of color. The authority he had carried all afternoon, his posture, his certainty collapsed inward, replaced by something closer to disbelief. He opened his mouth, then closed it again. No words arrived. The judge was still staring. Bumpy Johnson lifted his hand slowly, deliberately, and touched his cheek. Not to check the injury, to acknowledge the moment. He looked up not at Hanson, but at the bench. His voice, when it came, was calm enough to feel unreal. "Your Honor," he said evenly. "I'd like to note that for the record. 8 words. Nothing more." They cut through the silence with greater force than the slap itself. The judge found his voice. It was louder than before, sharpened by disbelief and authority reclaimed. The order came quickly, decisively. The bailiff moved without hesitation this time. Hands closed around Hanson's arm. The prosecutor protested weakly, an apology half-formed, unfinished. It did not matter. He was escorted away from the center of the room he had just lost. Whispers surged, then died under the strike of the gavel. The judge demanded order, but the courtroom had already understood the shift. What had been a trial minutes earlier was now something else entirely. The prosecution's authority had vanished, not because of argument, but because of impulse. The judge turned to the witness. "Mr. Johnson," he asked, his tone changed, now careful. "Are you all right?" "I am," Bumpy replied. No anger, no accusation, just fact. The question of charges hung briefly in the air, then settled. The defense rose composed, already thinking several steps ahead. The judge nodded. The jury watched, silent witnesses to a line crossed so publicly it could not be repaired. The slap had ended the case without a verdict. It had done what 2 years of investigation could not make the truth visible. Not about guilt or innocence, but about control. The man who struck had lost it. The man who absorbed it had not. Bumpy Johnson straightened slightly in the chair. He did not smile. He did not glare. He waited, patient as ever, as the system moved to correct the breach it could not ignore. At 2:34 p.m., the prosecution stopped being a threat. The case was already over. It just hadn't been declared yet. The phrase "I'd like to note that for the record" is recorded as a procedural request, not a provocative response in contemporaneous accounts of the incident. Order did not return when the gavel struck. It only tried. The courtroom had crossed a threshold it could not step back from. What had been procedure moments earlier was now evidence visible, undeniable, and witnessed by every person sworn to judge the case. The prosecutor was gone, escorted out under authority he no longer possessed. The air he left behind felt thinner, unsettled, as if the room itself was recalculating its limits. The judge sat still for a moment longer than usual. He did not speak right away. He looked at the empty space where the prosecution had stood, then at the jury, then back to the witness. This was no longer about maintaining decorum. That had already failed. This was about preserving the integrity of the process after it had been publicly compromised. Whispers rose again, softer this time, edged with disbelief. Reporters leaned forward. The bailiff adjusted his stance, eyes scanning the gallery. Everyone understood that whatever came next would not resemble what had been planned. The judge cleared his throat. He addressed the jury first, slowly, deliberately, as if choosing words that could survive scrutiny long after the room emptied. He acknowledged what they had seen. Not in detail. Not dramatically. Just enough to establish record and responsibility. The actions of the prosecution, he said, were unacceptable. They did not reflect the standards of the court. They could not be ignored. The defense remained standing, silent, ready. The question was no longer whether the case could be won. It was whether it could continue at all. The judge answered it himself. He declared a mistrial. The word landed heavily final in its simplicity. It did not need explanation. The reason was evident to anyone who had witnessed the last minutes. The misconduct had irreparably tainted the proceedings. No instruction to disregard could erase what had happened. No reset could restore neutrality. The line had been crossed too publicly. The jury was dismissed. Faces shifted from anticipation to stunned clarity. Some looked relieved, others looked unsettled, aware they had been present for something that would not be repeated in textbooks the way ordinary trials were. Bumpy Johnson remained seated as the decision unfolded. He did not celebrate. He did not react. He listened, hands folded, expression unchanged. Freedom had arrived without ceremony, delivered not by argument but by consequence. The judge turned briefly toward the defense, then toward the record. Additional steps would follow, he noted. Referrals, reviews, accountability beyond this room. The prosecution's conduct would not be forgotten when the lights went out. That mattered, because some cases end without verdicts, but they never end without consequences. The room began to empty in stages. Reporters moved quickly now, filing out to meet deadlines, already rewriting themselves. The gallery followed, quiet, thoughtful. This was not the ending anyone had predicted. It was sharper, cleaner, and far more damaging than a loss on the merits. Bumpy Johnson stood at last. He adjusted his coat, nodded once toward the bench, not in gratitude but in recognition, and stepped down from the stand. There were no comments, no statements, none were needed. The image would speak louder than anything he could say. The judge remained seated until the last juror exited. Only then did he rise, the weight of the decision visible in his posture. The courtroom would be cleaned. The calendar would move on. Another case would take this one's place. But this room would remember. The mistrial did not erase the trial. It preserved it frozen at the moment control failed. What had begun as a case built on paper ended because paper could not contain what happened in plain view. Justice had not been delayed. It had been interrupted and forced to respond. The mistrial was declared solely on the basis of prosecutorial misconduct as reflected in the court's formal ruling. The fall did not take months. It did not wait for appeals or quiet negotiations behind closed doors. It began immediately, carried forward by momentum that no one could slow once it started. Within hours of the mistrial, the story had escaped the courthouse. It moved through newsrooms faster than official statements could keep up. A prosecutor had struck a defendant in open court. The facts were simple. The implications were not. By nightfall, the incident had a name. By morning, it had a file. Robert Hansen was summoned before a disciplinary panel before the week ended. The room was smaller than courtroom 6. No jury, no spectators, just judges' records and a silence that did not invite explanation. This was not a trial. There would be no theatrics, no persuasion, no second chances disguised as arguments. The facts had already been established by witnesses who did not need to be called again. Hansen entered without the posture he once carried. The confidence that had defined his rise was gone, replaced by restraint that came too late to matter. He sat when instructed. He spoke when asked. He did not interrupt. The panel reviewed the record. They did not dwell on motive. Frustration was not a defense. Ambition was not mitigation. What mattered was conduct. A prosecutor sworn to uphold the law had introduced violence into a courtroom. He had violated the most basic boundary of his profession, control. When Hansen was given the opportunity to speak, he tried to explain. He spoke of pressure, of the length of the trial, of a defendant who remained unnervingly calm. He spoke as if composure were provocation, as if discipline were an insult. No one interrupted him. They did not need to. The response when it came was brief and precise. The panel made clear that what occurred was not a lapse. It was a breach, not of etiquette, but of trust. The law depends on restraint more than strength. The moment restraint fails, authority collapses with it. The decision followed quickly. Hanson's license to practice law was revoked effective immediately. There was no ceremony, no vote announced aloud, no dramatic pause. Just a conclusion delivered with the same restraint Hanson had failed to maintain days earlier. Years of preparation, a flawless record, a career built carefully, case by case, ended in a sentence. Outside the room, there were no supporters waiting, no cameras. The spectacle had already passed. This was consequence, not theater. Within days, Hanson's name was removed from the docket. His cases reassigned. His office emptied. Colleagues who had once praised his precision now spoke of the incident in lowered voices, careful not to sound sympathetic. The profession is unforgiving when its rules are broken publicly. Law schools took notice almost immediately. The incident was added to ethics discussions not because it was complex, but because it was simple. A reminder that the law does not bend to emotion no matter how justified it feels in the moment. Students would study the case not to analyze strategy, but to understand limits. What Hanson lost was not just a job. It was credibility. In law, reputation does not fade gradually. It collapses when trust is withdrawn. Once gone, it is not rebuilt. The irony was difficult to ignore. The case meant to define his career had done exactly that, but not in the way he intended. His name would be remembered not for convictions, but for the moment he lost control in front of everyone who mattered. The system moved on quickly. It always does. New prosecutors stepped into his place. New cases filled the calendar. Courtroom 6 returned to routine, but the lesson remained embedded in record and memory alike. Power in the law does not come from force. It comes from discipline. And when discipline fails, the fall is swift. The disciplinary record was released in accordance with New York State procedures governing attorney misconduct. Harlem heard about the slap before it read about it. News traveled first by voice barbershops, stoops back rooms where radios hummed and conversations paused when the story reached its center. A prosecutor had struck Bumpy Johnson in open court. The case had collapsed. The man who raised his hand had lost everything. But what Harlem remembered most was what did not happen next. There was no retaliation. No rush of men into the streets. No answer delivered in kind. In a neighborhood that understood how quickly public humiliation could ignite violence, the absence of reaction spoke louder than any threat ever could. Control had been displayed in full view, and it unsettled expectations. Local papers framed it carefully. Not as a victory, not as revenge, but as restraint. The images were stark: a courtroom frozen, a man struck, and another man who refused to strike back. The contrast was impossible to ignore. Power had changed shape in that moment, shedding noise and revealing discipline underneath. In community meetings and quiet gatherings, the story took on weight. People did not repeat the insult. They repeated the response. 8 words delivered without anger had done what years of confrontation had not. The system had been forced to act against itself not because it was attacked, but because it was exposed. Bumpy Johnson did not claim the moment publicly. He did not give interviews. He did not explain himself. That silence mattered. It allowed the story to belong to the community instead of the man. In Harlem, that distinction is everything. The message spread without slogans or speeches. Violence invites consequence. Control invites leverage. When one man loses himself in public, the man who keeps his composure gains ground no one can easily take back. You could feel the shift in tone. Conversations that once centered on force began to orbit around timing, around patience, around knowing when not to move. It was not idealism. It was strategy refined into instinct. Older men recognized it immediately. They had seen power exercised loudly and watched it burn out just as fast. Younger ones learned something harder to teach: that restraint is not weakness when it is chosen, that the most dangerous response is sometimes none at all. The courtroom incident became shorthand, not for humiliation, but for consequence. When tempers flared elsewhere, someone would mention the trial. Not as a warning, but as a reminder. The man who struck lost his future. The man who absorbed the blow walked free. That was not myth. That was record. Bumpy Johnson continued his life without referencing the moment that had redefined him in the public eye. He did not need to. The image had already set. A man sitting still while authority collapsed around him. History often favors noise. This time it favored silence. The legacy of that afternoon did not rest in law books alone. It lived in how Harlem recalibrated its understanding of power. Not as something seized in rage, but something preserved through restraint. Not as dominance, but as composure under pressure. What remained was not a lesson delivered from a podium, but one absorbed through observation. The kind that lasts longer because it was not explained. The power of not hitting back is rarely visible in the moment. It reveals itself later in the fallout. In who remains standing. In who is remembered for losing control. In that courtroom, the roles reversed without a word spoken about it, and Harlem took note. Community reactions described here are drawn from contemporaneous local reporting and later accounts from individuals present in the neighborhood following the incident. No verdict was read that afternoon. No sentence was handed down. No gavel fell to declare a winner. The courtroom emptied without the sound of justice being officially named. There was no blow returned. No shouted triumph. No moment that could be mistaken for a celebration. Yet inside the very room he believed he controlled a prosecutor, lost everything: his authority, his career, his future. A man everyone expected to break walked out free. Not because he fought back, but because he understood something most people learn too late: when the other side loses control in public, you have already won if you can remain still. The law did not collapse because of a slap. It faltered when emotion replaced restraint. And it corrected itself only when silence exposed the failure. Some files close without verdicts, others remain open because the lesson still matters. This was one of those cases, and there are more like it waiting to be examined. And if you had been standing in that courtroom facing authority witnesses and public humiliation, would you have struck back in the moment? Or trusted history to record what you didn't do?